Probably most of you are surprised by what happened this morning. I don't want there to be any misunderstanding. We are not in any way conceding guilt. In fact, Jerry is more adamant than ever in his innocence and in expressing his innocence at trial. Today's decision was simply a tactical measure based upon an analysis of what was going to transpire. Most of you who have spoken with me over the course of the last 5 weeks realize that today's proceeding was only a preliminary hearing, a probable cause hearing. It was not a trial. We would not have been able to present any witnesses. We would not have been able to present a defense. In fact, we could not even have tested the credibility of the Commonwealth witnesses. All that would have happened today is that the Commonwealth would have had an opportunity to basically recite the allegations contained in the presentment that has been presented and filed against Jerry Sandusky in this matter, which really would have left us with the worst of all worlds. We would have heard a recitation of the allegations without realistically being able to cross-examine the witnesses who testified as to their credibility. And as all of you know, credibility is sort of the main factor in this case. Credibility is a situation that exists at trial. It's a measure which we can address at trial, but we could not have addressed today. And had we attempted to, I suspect we would have been foreclosed from doing so. One of the main reasons that we wanted to have a preliminary hearing and anticipated having one was because we wanted to be able to cross-examine Mike McQueary, who was involved in the allegations pertaining to accuser number 2. As most of you know, the credibility of Mike McQueary has been put into great question prior to today with various statements he allegedly has made, and we've verified the emails, but we still have not yet verified the comments allegedly made to Dr. Drainoff following whatever Mike McQueary said he saw in the shower room at Penn State University in March of 2002. Having done that, and having realized that Mike McQueary's credibility was already a grave issue, we decided that when we looked at the strategy that we wish to apply in this case, that would make a lot more sense to waive this hearing and proceed with our defense, especially given the fact that we got a concession from the Commonwealth to address our pretrial discovery needs and requests in a reasonably fast way so that we can analyze that material more quickly and properly prepare for a trial. So again, having said that we anticipated nothing new coming out of this case by way of our defense, not being able to realistically present a defense or attack any witness's credibility today, we decided late last night that the better part of the tactical maneuver from our standpoint would be to waive today's proceeding, being very well prepared and realizing that we have much of the evidence we would have gained from today's proceeding without proceeding with it, putting everyone to the task of sitting in court for an entire day's worth of court hearings. Now, having said that, I'll be happy to answer any questions.
Joe, you do all.
Now, wait, I want to control this. I can't answer 5 or 10 questions.
Did you flag this to prosecutors as a possibility last night in your discussions, and what all did you discuss with them?
Well, what we discussed was if we were to waive the hearing based upon the realization that a probable cause hearing, which is what a preliminary hearing is a really low threshold of proof for the Commonwealth. All they have to do is establish the elements of the offenses, and the case is held for court on those charges. So realizing that, realizing credibility was not going to be an issue, and in fact, the prosecutor, I think, correctly stated that he would object to any questions I wanted to ask about credibility. And having given that information, we talked about if we waive the hearing, would they facilitate discovery, for example? Would they agree to maintain bail where it is, for example? Because I think most of you realize that a client who's not incarcerated is a heck of a lot more valuable to his attorneys in terms of preparing his defense than an attorney who's in jail. So we made those agreements, and based upon those agreements, we decided that we would waive the hearing today. If in fact these young men were abused as children, then obviously there's a real issue as to whether or not they're being victimized by the process, not by us, but by the process. But on the other hand, ladies and gentlemen, if Jerry Sandusky is innocent, if he's innocent, which he has maintained, then maybe he's being victimized because he's going through this process. He's being followed day and night. He can't leave his house. Of course, now he's under house arrest. But media has been outside his home 24/7 for the last 5.5 weeks. So to answer your question, if in fact it turns out that these young men were victimized, were in fact victims, then certainly the process is causing them great hardship again. But that's the nature of the legal process. But on the other hand, Jerry has maintained his innocence, and as most of you know, in the legal process we have a great system that people who are charged with offenses are simply charged. They're not guilty, they're presumed to be innocent. And all we've asked from the media is to give Jerry Sandusky that opportunity to prove his innocence in a court of law.